This was an interesting term, not as many blockbusters necessarily as in past years, but plenty to chew on. And there are individual videos about the biggest cases. I want to talk about 3 others that might get overlooked. Knick was the biggest property rights case of the term, probably the biggest property rights case in some time, even though it was a procedural case. That is, it was about whether you have to first go to state court to bring your claim that the local government has taken your property in violation of the Fifth Amendment, or whether you can go straight to federal court. Rosemary Knick said that we shouldn't treat property rights like second-class rights. If the local government is censoring your newspaper or the police are banging into your home without a warrant, you don't have to go to state court to pursue your remedies before you make your First Amendment or Fourth Amendment claims, respectively, in federal court. But the way that takings claims work, because of this doctrine, as it's developed over time and crystallized in the Williamson County case in 1985, you first have to go through the state process, and then if your claim hasn't been vindicated, you haven't been given just compensation, then you perhaps can get into federal court. Mrs. Knick was saying this is not fair, it violates my Fifth Amendment rights, why don't I get my day in federal court? Williamson County was wrong. The township argued that there is no violation of Mrs. Knick's constitutional rights until and unless they actually denied her just compensation. And the state court proceedings were precisely to determine whether this was a taking that's subject to the just compensation requirement, and then figuring out the amount of that compensation. This was one of the handful of cases this term where a previous decision of the Supreme Court was overruled. And so naturally we go back to this argument back and forth over stare decisis. Justice Kagan in dissent said that the court was overturning not just Williamson County, but over a century of property rights jurisprudence. Chief Justice Roberts from the majority said, no, those older cases are still valid. All this is saying is that if there's a taking, you can sue right away. Return mail versus the United States Postal Service is a case that raises the key statutory interpretation issue of whether the government or a government agency is a person for purposes of the America Innovates Act, for purposes of challenging a patent or related issues, and secondly, whether there are separation of powers concerns that are raised when an agency of the executive branch seeks to challenge the determination of another agency, here the Patent and Trademark Office. Return Mail is a small company that owns a patent on processing mail that's returned as undeliverable. Return Mail tried to get that patent licensed to the U.S. Postal Service. The Postal Service refused and instead sued in the Patent and Trademark Office to get that return mail patent invalidated. It seems odd to have the executive branch suing itself. It's one thing to have the House of Representatives suing the administration, but to have a lawsuit within the same branch of government defies the logic of the separation of powers. It's something odd and not really provided for in our constitutional structure to have one agency, here the Postal Service, challenging or asking a court to second guess the determination of another agency, the Patent Office. And the court ruled 6-3 that under the AIA, the government or a government agency is not a person that can intervene in these disputes over the validity of a patent, not needing to reach the separation of powers question, but indeed it would be an odd thing to allow one part of the executive branch to sue another. Manhattan Neighborhood Network is a public access channel operator that got permission from Time Warner to run the public access programming. Under federal law, when you're a broadcaster, you have to give certain parts of your cable network over to public access, locally produced content. Halleck, another filmmaker, made a film critical of the Manhattan Neighborhood Network itself. After that, we're banned from the public access channel. Halleck argued that because Manhattan Neighborhood Network got the power to decide who gets access through the public access facility, they were acting as the government, as a state actor. When the government acts in a way that discriminates based on viewpoint, that's a First Amendment problem. Manhattan Network's argument was that it was not an arm of the government. Nobody told it, neither Time Warner, let alone New York State or the city or anyone else what to broadcast. In the past, private actors, whether companies or individuals, have only been held liable for First Amendment violations if they've been working directly for the government at its command, not as a licensee. And that's ultimately what swayed the court here. This was a 5-4 decision holding that Manhattan Neighborhood Network was not a state actor because it was not a public broadcaster. Just because they were allowed to use the public access channel and determine what kind of content was there did not mean that the government was making those kinds of content or viewpoint-based decisions.